Good afternoon. This is Scott Horton. I will be presenting today's webinar. We are scheduled to get started in just a couple of minutes. The webinar is now live, so people are just starting to enter the room. We'll give everyone time to do that, and then we will get started. Hello, thanks for joining us today. This is the webinar on New York Predictive Scheduling Regulations. I will be presenting. This is Scott Horton of Horton Law. We will get started in just a couple of minutes as everyone is joining the webinar now. You should see the cover slide on your screen for the presentation. There is no video feed of me speaking, so if you have the cover slide that says New York Predictive Scheduling Regulations and you have access to the chat window where you can ask questions during the presentation, then you should be all set. Again, I will get started in just a couple of minutes at our scheduled start time. Thanks for joining us. Again, there is a chat window where you can enter questions. I will hold a question and answer primarily at the end of today's presentation. We will try to keep this to about 1 hour, including the question and answer, but I generally will stay on as long as there are still questions. We will get started in just another minute or two as folks are still logging in to the webinar. So I'll say this again just as we get started. If you do have questions throughout the webinar, you can go ahead and type them into the chat window at that time, but I will usually wait until the end to answer questions unless it's something particularly relevant, and I think it will help us move forward. Otherwise, we'll just collect the questions throughout the presentation and answer them at the end. We are now up to our start time, but I will give another 30 seconds or so, and then we will get going with today's webinar. Okay, good afternoon. Everything looks good on our end, so I'm going to go ahead and get started. This is our webinar on New York Predictive Scheduling Regulations, just in time or still on call. I am Scott Horton, founder and attorney with Horton Law, PLLC in Orchard Park, New York. I am a management side labor and employment attorney, and I regularly present these webinars on a nearly monthly basis. So if you are registered for this program, you will, unless you happen to opt out, receive announcements of our future webinars, and we encourage you to join us for those. Today's topic is a little bit of an interesting one, as we'll be discussing rules that have been proposed essentially twice now by the New York State Department of Labor, but which are not yet in place. So the majority of what I'm talking about today is not currently in effect, so keep that in mind up front. but it has been proposed and could come into effect in the relatively near future in some form, likely very close to what I'm going to be describing today. As we get started, I just want to say one more time for those who are just joining that I will answer questions at the end. Try to keep the whole presentation to about an hour, but if questions continue, I will stay on and answer the questions as long as I can. Type those in the chat window as you have them, although I will generally wait until the end of the presentation to answer specific questions. The other note that I just have for you is, although I am an attorney and do represent businesses regarding matters like what I'm discussing today and other employment topics, this presentation cannot be considered legal advice because I'm not talking to you specifically about the circumstances in your business, which may or may not require exceptions and alternative considerations. Likewise, there's no attorney-client privilege between us if you ask a question in the presentation. So keep that in mind. If you have something very confidential that you don't want to share publicly through the webinar, then take care not to do so in asking your questions. With that, I want to get started, let you know what we're talking about. Again, there are proposed rules that would affect many New York employers throughout the state. I will explain more carefully which employers that includes and which are excluded. But I want to start with a little timeline to let you know how we got to where we sit today. The first action in effect at the state level goes back to September of 2017 when Governor Cuomo called for public hearings on employee scheduling. So this was a directive essentially to the New York State Department of Labor to review its regulations related to call-in pay, most specifically, as we'll get to, and I'll show you what the existing regulation on call-in pay looks like. So there were hearings held following that directive in September of 2017, and by November of 2017, the State Department of Labor issued its initial set of proposed regulations on this issue. That first set of regulations was very scary to people like me, attorneys that represent businesses and employers in a wide range of employee matters, because these regulations were very restrictive with respect to how many employers would be able to schedule their employees going forward. The similar path at the city level in New York City was going on, which I'll get to in a minute at that time, but this was a statewide initiative from the governor's office and the State Department of Labor, but it really didn't progress very far over the course of the next year after the initial regulations were put out. People like me, or at least I know I was, happy that there had not been any formal action to finalize the rule or put it into effect. I think many were hoping that the proposed regulation had sort of died on the vine based on significant opposition from business and employer groups. But unfortunately, again, from my perspective, representing employers and frankly, as a small business owner and employer myself, there were new revised regulations proposed this December 2018. So just over 2 months ago now. Those new regulations were very similar to the 2017 version with a couple of tweaks and edits, but for all intents and purposes were just as daunting and objectionable, again, from my standpoint. They did carry a 30-day comment period from the Department of Labor, which has now passed in early to mid-January, so a little over a month, 6 weeks ago. Now What that means, I think, is that we can expect at any point in time that the Department of Labor would issue final regulations and let us know both what they are and when they will take effect. Of course, it is also possible, as happened from 2017 to 2018, that those regulations will not come forward with haste, but given that they've now published these proposed regulations twice and sought comments twice, I think it's unlikely and probably unrealistic to hope that there will be nothing that comes from this. I did mention the New York City sort of parallel initiatives in November of 2017. New York City had local laws take effect known as the Fair Workweek Law. The Fair Workweek Law affects specifically fast food and retail employers in New York City. For the purpose of this presentation, most of you are probably not even in New York City and not in the fast food or retail industry, so I'm not going to go into too much detail as to which fast food and retail employers are covered, but the coverage is relatively broad. Again, if you are operating in those industries within New York City, the requirements differ somewhat between the two segments of industry that are covered. For example, fast food employers must set schedules 2 weeks in advance for their employees. And in retail establishments, the law actually says that no on-call shifts are allowed. Pretty daunting restrictions. And frankly, those probably aren't even the most burdensome provisions of the New York City Fair Workweek Law from employers' perspectives. There is now serious litigation pending challenging these laws. So in December, large restaurant organizations and associations did file a lawsuit attacking the New York City Fair Workweek Law as invalid, and that legislation is in the very early, or that litigation is in the very early stages challenging that local legislation. But these types of requirements in New York City, as you will see, are in some respects similar to what is being proposed at the statewide level. So there are questions in New York City as to how the state regulations would interact with the city requirements, which are different for fast food and retail employers. As we'll talk about in just a second, actually, the fast food industry in New York City is probably not even subject to the proposed state regulations, but the retail employers, for the most part, could be. So guys, wanted to mention the New York City law. This isn't a discussion specifically on that law. We're talking about a proposed statewide regulation. But it is important to clarify which employers and the way the rules work, actually which employees specifically would be subject to the proposed rule. The proposed rule would modify New York State's minimum wage order for miscellaneous industries and occupations. Kind of awkward the way this minimum wage order works, but essentially that is the most broadly applicable minimum wage order, which is not exactly the minimum wage law in New York State, but it is the set of regulations that governs things like minimum wage and overtime conditions and exceptions throughout most of New York State for most industries. The rule actually has parallel sets of provisions. They are separately numbered in the minimum wage order, but they are identical. The only difference is one set applies to nonprofit organizations and the other for for-profit businesses. So if for some reason you need to look at the specific rules, just know that there are two sets, but they, at this point at least, say the same thing. The minimum wage order applies to private, that is non-governmental employees who are not covered by other wage orders. The other wage orders are the hospitality industry wage order, which essentially means restaurants and hotels. The building services industry wage order, which is a little bit more difficult to classify, but includes businesses engaged in renting, servicing, cleaning, maintaining, selling, or managing buildings or building space, and all occupations, operations, and services in connection therewith or incidental thereto. So if you manage or operate a building, an office building, or a residential building, then your organization probably fits within the building services industry. If you are a construction company that simply works on those buildings, however, you probably do not fall within the building services industry. Again, there are some nuances. The other wage order in New York State is the farm workers wage order. So it's pretty clear what that includes: employees who literally work on farms, not in canning or processing facilities, but both livestock and vegetable and fruit farms in New York State. So if your business is not in one of those industries, then it is likely to fall under the minimum wage order for miscellaneous industries and occupations, barring some really limited exception. The other thing I should mention is, as I'm going throughout the rest of this presentation, I'll be using the term employees to talk about what the new requirements are for the purposes of the minimum wage orders and these proposed scheduling rules. Employees does not include the employees who are exempt generally from minimum wage and overtime law under the executive, administrative, professional, or outside sales exemptions. So although theoretically the two are not exactly overlapping, basically if you have someone who is exempt from overtime, they may well not be subject to the rules and protections that we are talking about here today. Just real briefly, I just thought I would throw out a quick poll to see which of the industries are represented by people in the webinar today. So I'm going to throw this question up, and if you could just click one of the industries that I've just mentioned based on the New York wage orders. So most of you, probably even a higher percentage than we are seeing in the poll, based on responses so far, are in the other miscellaneous category. There are some of you there are some of you in the hospitality and building services industry, and I've just told you that these proposed rules won't apply to your industries, but I don't want you to necessarily tune me out or stop paying attention or turn off the webinar, because on the website related to this process and the hearings and the regulations at the state level, the Department of Labor has put this note that the scope of these hearings focused on scheduling practices for workers subject to the minimum wage order for miscellaneous industries and occupations. But it then adds other industries will be evaluated after this review. I think especially with the hospitality industry, which is probably the largest group of employers that are not covered by the miscellaneous wage order, it is reasonably likely that if and when these regulations are put into effect, there will be reconsideration of similar aspects of the hospitality industry wage order. And I will show you in just a little bit what the current requirements are in the hospitality industry and how they compare and contrast from the current requirements in the miscellaneous industries throughout New York State and how they compare to what is being proposed for the miscellaneous wage order. The current provision of the miscellaneous wage order that these proposed rules seeks to modify reads as what you see on your screen now. It says in a provision called call-in pay, an employee who by request or permission of the employer reports to work on any day shall be paid for at least 4 hours or the number of hours of the regularly scheduled shift, whichever is less at the basic minimum hourly wage. So it is possible that a couple of you are sitting there wondering now, do we actually pay our employees in accordance with this provision? We've had people that we've called in who've worked less than 4 hours. Maybe their regularly scheduled shifts are 8 hours. Do we owe them more money? Should we have paid them more money? And while it is possible that you do, or you should have, it is also possible that despite this existing rule in the wage order, you don't actually owe employees anything more than what they have been paid. And that is because of this last part of the rule, which I highlighted in green, not in green in the Department of Labor's wage order, of course. But the part that says at the basic minimum hourly wage has been consistently interpreted by the Department of Labor to essentially mean that you don't have to actually add compensation pursuant to this rule if the total pay to the employee over the work week ensures that even with this extra theoretical number of 4 hours or their regularly scheduled shift, whichever is less, if you added that to the number of hours they worked and then divided it into their total compensation, as long as they are receiving at least the basic minimum hourly wage over the work week, then they don't get anything additional. So the current call-in pay provision in the miscellaneous wage order primarily only comes into play for employees who are paid at or very close to the minimum wage, and or would have multiple of these call-in shifts during a week. So it does happen. There are some cases where you should be paying up to an extra 4 hours, or not extra 4 hours, but up to 4 hours even for shifts that are less than 4 hours of actual time worked. But it's possible that by paying more than the minimum wage in the first place, you have offset that potential obligation. Sorry, I do see a comment in the chat that someone saw the poll, but nothing else on the screen. If you also are not being able to see the slides on the screen, please comment and let me know. I think most people are able to, so all I can do is suggest closing some other applications on your device, for example, and logging back in. It's also possible that if you're viewing on a mobile device, especially a smartphone, then you might have more limited access than others. But for the most part, everything appears to be working from my end. So again, this is the current rule in the miscellaneous wage order, and this is the rule that the Department of Labor is proposing to change. And now what I think I'm going to be showing you next is the proposed new rule. And as you can see, I started out in the same font as I put for the current rule, but quickly it becomes obvious that this will not all fit on one slide in that font. So I had to make the typeface much smaller to continue listing the proposed new rule. Don't worry, I don't actually expect you to read this or be able to see it, but it is there. It's probably visible. I should have mentioned the slides will be made available at the end of the presentation so you can have a copy. I'll give you a link to those. But we're going to go into this more detail. I just wanted to show you how much more extensive the proposed rule is compared to the current rule. And oh, by the way, that was only half of it. Here is the rest of the proposed rule. Again, in relatively microscopic font. Obviously, the Department of Labor is proposing extensive revision to this very limited existing call-in pay provision. And again, editorializing, I will say that there's nothing in here that is better for employers than the current rule, at least in all but the most, peculiar circumstances, or based on the theory that the Department of Labor itself mentions in comments to its proposed rules, that predictability in scheduling will lead to better employee retention. So now that I've given you the proposed rule and shown you how complex it is, and acknowledge that this rule is not currently in effect, some of you may just be ready to stop right here. That's where I was a year ago, frankly, when the Department of Labor was not promptly issuing a final rule based on its initial proposal. But now I think that they've reproposed the rule. We have to guess that it is quite likely that they are going to implement a similar rule in the very near future, if not exactly the same, with probably limited tweaks. So I will go ahead and continue the discussion, and we have plenty of time left in our hour, so that shouldn't be surprising, and I will describe for you much more detail, as unfortunately there is much more detail in the new proposed statewide call-in pay regulation. As I mentioned, I do want to show you the current rule in the hospitality industry. There are a couple of you that probably do fall into that industry, and kudos to you for paying attention to this presentation, even though the currently proposed rules don't directly affect you. The current rule in the hospitality industry is on this slide. I kept it in the same font size as the proposed rule in the minimum wage order, and that just to sort of make it easier for you to compare and contrast sort of the length and scope of the rules. So clearly the hospitality industry rule is longer than the existing miscellaneous industry call-in rule, call-in pay provision, that is. But it's not anywhere near as long as the proposed rule that the Department of Labor is currently considering implementing. And frankly, the existing hospitality industry rule, while it does have more teeth than the miscellaneous industry rule, for example, it doesn't allow that sort of safe harbor or offset where employees already paid above the minimum wage probably don't often need to get paid separate call-in pay. The hospitality industry does sort of still require actual additional pay in some of those situations. But this rule that you see on your slide, albeit in tiny font, could pretty easily be consolidated into probably 2 or 3 sentences. There's some stuff here that it's probably clarification more than anything and really doesn't need to be said. That they're just contrasting perhaps to distinguish it from the miscellaneous industry wage order, or in the guise of making it easier to understand. Hesitate to concede that that was accomplished through this rule. But by any means, it is much more concise and has much less restriction, imposes much less restriction than the proposed miscellaneous call-in pay rule. So let's talk about what the proposed miscellaneous industry call-in pay rule would include. I think it's easy to concede that this is a much expanded call-in pay provision. And in fact, it essentially converts the simple call-in pay provision into 5 separate categories of call-in pay, if you will, all geared toward requiring employers to provide more notice to their employees about when they're going to work, or failing that, requiring employers to pay their employees extra money as the alternative to giving them the scheduling information in advance. So we will go through each of these 5 categories separately over most of the remaining time we have, and you will see that you know, any or all of them could affect your business if you're not already in the hospitality industry or the building services industry, and even in those industries if these rules were to be expanded into those wage orders down the road. I talked about sort of the exceptions before, including the exempt employees and governmental employees and those covered by the other wage orders. The new rule doesn't exactly use this language, but for sake of simplicity, I'm calling these exclusions. So there are essentially sort of some more exclusions from the coverage of the rules. First of all, there's virtually complete exclusion for unionized workers who are, quote, covered by a valid collective bargaining agreement that expressly provides for call-in pay. Assuming that's maintained in a final rule, I would ideally like to see some modification of that language. I'm not sure what a valid collective bargaining agreement is. Is that one that's not expired, or is that one that's not in dispute somehow? And what does it mean to expressly provide for call-in pay? What if it's clearly call-in pay under another name? Is it on call? If it just says on call pay, does that provide exceptions to the on call provisions of the new call-in pay rule? So there's still some ambiguities there. But if you have a collective bargaining agreement that covers this subject, it is possible that all of these rules would not apply to those employees. There are also what I'm calling partial exclusions for employees who earn more than 40 times the respective minimum wage in the applicable work week, which I'll come back to. Employees whose duties are directly dependent on weather conditions or are necessary to protect the health and safety of the public or any person. So in the healthcare space or, sort of public physical service type of space, but this would probably be more limited to utility companies on the dependent on weather conditions than snowplows, for example, because most of those would be public employees. Although I suppose if you did have a private snowplow company, then this partial exclusion might apply. And then there is a partial exclusion for employees whose assignments are subject to work orders. Unfortunately, there's not any specific elaboration on what qualifies as a work order or an assignment subject there too. Does this only apply to sort of construction industry type work order? Does it apply more broadly to customer invoices or purchase orders? There's actually some suggestion in the commentary to the proposed rule that customer orders might be the type of thing that's meant to be included by this work orders notion, but those are sort of open questions. And again, these are only partial exclusions, and I'll explain where they come into play as we go forward. The first one is probably the most important and the most broadly applicable. Employees who earn more than 40 times the minimum wage in the applicable work week become excluded for that work week. What does this basically mean? Whether you have to pay call-in pay for an employee in a specific work week, could depend on whether essentially they're full-time. If they are full-time working 40 hours a week, and assuming you're paying them minimum wage, then most of these rules would not apply to that employee during that work week. But employees who don't make much more than minimum wage and or who work considerably less than 40 hours in a week would not meet this exclusion, perhaps. So that means that these requirements are really more burdensome with respect to part-time employees, burdensome for employers with respect to part-time employees, which coincidentally are probably ones that as a group are more likely to be scheduled in the ways that these rules seek to prevent. The respective minimum wage that I have here is only to acknowledge that the minimum wage is higher now in New York City than it is, for example, in Buffalo. So just you need to look at that. And also note that this is a work week by work week basis. So an employee who normally works 40 hours in a week, but only works in a particular week 20 hours, and assuming they're not paid too much more than the minimum wage in the first place, could be subject to these scheduling restrictions in that week, but not others. That actually creates some logistical problems in applying the other rules because some of them are not only based on what happens in a single week. They depend a little bit on how long this person was scheduled in advance and that type of thing. There's a lot of complexity in these rules, let's be honest, at this point. And since they're only proposed rules, the goal of this presentation is really not to make you an expert on these requirements, but it is to at least let you know the breadth of the potential regulations that could come into play virtually any time now, and potentially without a whole lot of ramp up time for employers. There is a note in the commentary to the proposed rule that acknowledges that employers would need at least 14 days to come into compliance with these rules before they took effect. As with most aspects of the commentary to these rules, I think that's kind of a farce, if I'm being honest and allowed to editorialize. The commentary also does not anticipate that this rule will have an adverse economic impact upon small businesses, for example, nor will it impose new reporting, record keeping, or other compliance requirements upon them. Okay, sure. In a lot of organizations, this is going to be a significant administrative burden and hence costly addition to what human resources departments and managers have to deal with on a day-to-day basis. But let's go through the rules themselves, or sort of the new affirmative parameters on scheduling. As we go, I'm going to mention those exclusions that I talked about and sort of how they work into the different components of the new requirements. So first, what was the call-in pay provision? So the entire rule before is now called reporting to work, but the language that previously existed has been changed. Honestly, it's shorter than it was before, this one particular provision, but that's only because they made it worse for employers. So now it reads, an employee who by request or permission of the employer reports to work on any shift where it said day before shall be paid for at least 4 hours of call-in pay. So at first it allows that someone could actually be eligible for multiple call-in pay, multiple call-in pays for the same day if they're called in multiple times, whereas before it was based on the day. And that last provision of call-in pay is what replaces the reference to the basic minimum wage. So now, separate and apart from whether the person makes enough over the course of the week to have made minimum wage for all hours worked, plus the call-in pay time, now there is actually an affirmative additional compensation requirement anytime this provision is triggered. The note about this is the only form of call-in pay that would apply to employees subject to the partial exclusions on the previous slide. So if these exclusions apply, the partial exclusions that is, then you would still have to pay this type of call-in pay. There are 4 other categories that you could have those types of employees be included from if those conditions apply in a given work week. So I have the next rules entirely underlined to show that this is all new language, where over here on the reporting to work, there were just a couple of terms changed with material impact. The next 4 types of quote unquote call-in pay are all entirely new additions to the minimum wage order. The next one, the regulations call unscheduled shifts. An employee who by request or permission of the employer reports to work for any shift for hours that have not been scheduled at least 14 days in advance of the shift shall be paid an additional 2 hours of call-in pay. Where an employee provides a weekly schedule, 14-day period referenced in this section may be measured from the last day of the schedule. That second sentence, I think, was added in the 2018 proposed rules and hadn't been in the 2017 proposed rules, and I think it's supposed to be sort of a give back to employers, but you know, I think it's hardly any consolation in almost every case. But the first sentence basically says unless an employee is exempt or excluded, they will have to get their schedule at least 14 days in advance. If they're not, then each such shift that they didn't receive 14 days notice of, they will be entitled to be paid an extra 2 hours of call-in pay. There's a slide at the end that refers to call-in pay calculations. So when you see references here to call-in pay, we'll talk about what that means. More or less going to mean what they're normally paid. But it's a little more complex than that because, of course, everything about this rule is complex. There is another partial exclusion here that's important, if only because of how much space they took up in the proposed regulations to talk about it. This 2-week schedule, advanced schedule notice requirement doesn't apply to employees during the first 2 weeks, which is helpful that you didn't have to essentially wait 2 weeks to schedule someone. And there's also a partial exclusion here for an employee who volunteers to cover a new or previously scheduled shift. So this is the idea of, you know, employee A calls off and employee B says, oh, I'm happy to take their shift for them. The question that the rule anticipates is, what does it mean to volunteer? So happily, they created a safe harbor provision that creates a rebuttable presumption that the employee has volunteered to take a shift if, and then a whole bunch of words that mean something apparently super complicated, or at least appears to me to be super complicated. To have this rebuttable presumption, the employer has to provide a written good faith estimate of hours to all employees upon hiring or after the effective date of this section for previously hired employees, which may be amended at the employee's request or upon 2 weeks' notice by the employer, and if the request to cover a new or previously scheduled shift is either 1, made by the employee whose shift would be covered, or 2, made by the employer in a written communication to a group of employees requesting a volunteer from among the group and identifying a reasonable deadline for responses. And then it goes on to say, if no employee volunteers prior to the deadline, the employer may assign an employee to cover the shift without the additional call-in pay required for unscheduled shifts. The wording's not perfect. The reference to the rebuttable presumption, does that just apply to whether someone has in fact volunteered, or to this last sentence that seemingly allows employers to compel someone to take the shift without having to pay call-in pay if they've jumped through all these hoops? I think the latter at least is true. I don't think this means that it won't be considered a volunteer situation if, otherwise it's clear that the person volunteered. But again, this is the extent of machinations that this rule goes through, I suppose, to try to give employers a little bit of a give back on what are pretty clearly additional regulations and restrictions on their scheduling prerogatives. There is a canceled shift category now in call-in pay. This pertains to, with some great wording again, an employee whose shift is canceled by the employer shall be paid for at least 2 hours of call-in pay if the shift is canceled within 14 days, or for at least 4 hours of call-in pay if the shift is canceled within 72 hours in advance of the scheduled start of the shift. So if you had someone on that schedule, and hopefully assuming you had scheduled them 14 days in advance if you were subject to that first requirement, and then cancel the shift within the 14-day period, then you have to pay them 2 hours of call-in pay for the shift. If you have to wait until less than 3 days before the start of the shift, then you have to pay them 4 hours of call-in pay. There's now an on-call requirement, which, historically I think would have been distinguished from call-in pay. On-call pay normally meaning something different and something that in most cases has not been required by New York law, might be common under collective bargaining agreements. And then there are circumstances where an employee who is on call would be deemed to have worked for purposes of minimum wage and overtime laws. If they, the classic case is, I think, the firefighter who's sitting in the fire hall waiting for the fire call. But there are other questions on an employee by employee basis of, how restricted is this person and what they can do when they are on call as to whether they are deemed to be working and therefore required to be paid minimum wage or overtime. But now, to some extent, resolving any ambiguity there, the Department of Labor is proposing an on-call requirement that says any employee who is required by the employer to be available to report to work for any shift shall be paid for at least 4 hours of call-in pay. So there's a situation where the employee is not actually even called in, but is on call, whatever that means, available to report to work. And the level of requirement that's necessary is not explained, but such a person is eligible for 4 hours of call-in pay, even if they don't get called in. There is also a call for schedule provision in the new regulations. An employee who is required by the employer to be in contact with the employer within 72 hours of the start of the shift to confirm whether to report to work shall be paid for at least 4 hours of call-in pay. Not sure actually whether this would be cumulative and in addition to the canceled shift provision, if the person does call in and finds out that no, they're not required to work, are they then entitled to the 4 hours of call-in pay under the canceled shift provision, in addition to 4 hours of call-in pay under the call for schedule provision? My guess and assumption would be that one might have to assume that both apply and are cumulative, but there's not a lot of clarity on that particular aspect, I don't think. Now, that was all the categories of call-in pay under the proposed regulations. I know this is super wordy and complicated, but I'm trying to break this down as well as possible at this point in time. There are a couple of other partial exceptions beyond the other partial exceptions I already talked about, which are a little more broadly applicable. The unscheduled shift and canceled shift provisions don't apply when an employer responds to weather or travel advisories by offering employees the option to change their schedules. So if the weather is going to be bad and you say, why don't you leave early and come in early tomorrow to make up the time, or either or both of those, there might be a partial exception there. And the canceled shift provision doesn't apply when an employer cancels a shift at the employee's request for time off, or when operations can't begin due to an act of God or other cause not within the employer's control. Not sure how broadly that will be interpreted, but the example given is a government declared state of emergency. So other cause not within the employer's control could be anything, considering we're already talking about a situation where the employee is the one requesting time off in some cases, or when operations can't begin. But that is the way those provisions read right now, again, in the proposed regulations, but no guarantee that they will be clarified. I did say there were directives on how to calculate call-in pay. And again, this is complicated enough. I'm going to go into too much detail on this, but it's here. Again, the slides will be made available to you to download. The parameters of what call-in pay means depend on a couple of different things. First, did the person actually attend and work? Payments for time of actual attendance have to be paid at the employee's regular rate of pay or overtime pay, minus any allowances permitted under this part, which means under the minimum wage order. Payments for other hours of call-in pay shall be calculated at the basic minimum hourly rate with no allowances. So I kind of glossed over this initially because I knew we were coming back to it. So when the person actually comes in to work, then their call-in pay is their regular pay rate. When they don't actually come in to work, then call-in pay is the minimum wage. There are no offsets in that second row starting at the left. Call-in pay is not offset by the required use of leave time or by payments in excess of those required under this part. This directly modifies the prevailing interpretation of the current rule, which again says if you've already paid more than the minimum wage plus the number of hours that the person would get call-in pay, then you don't have to pay additional money. This just says that no, when you trigger a call-in pay requirement, you actually have to pay call-in pay, which either is their actual rate of pay or the minimum wage, depending on the circumstances. And then there is a partial clarification for shorter work days. The 4 hours of call-in pay for reporting to work and for canceled shifts may be reduced to the lesser number of hours that the employee is scheduled to work and normally works for that shift. I guess it was just easier to pull that out rather than going back and putting it into each of the separate provisions. So if their shift is normally less than 4 hours, then you might get a partial reprieve in the amount of call-in pay that has to be paid out. So with that, we have gotten to the end. I'm going to take questions. We got a good period of time here, left in the hour. If we don't have questions to fill that time, we'll wrap up a little early. If there are additional questions, I'll stay to the end. This is only a very brief advertisement. I do have a book on New York employment law that is available online through Amazon and Barnes and Noble and the like. If you're interested, it's been a helpful resource to clients and others who have used it. It does not address the call-in pay, the proposed call-in pay provisions, because it came out last year before there was any certainty that these would be put into effect. But that is available. I appreciate those of you who have stuck with me through this relatively complicated but potentially very important and, in my opinion, likely burdensome new, I'm going to call it, set of regulations, even though technically it only changes one rule. I will make the slides available in just a minute, but go ahead and type in any questions that you do have at this juncture. I did just want to note too that, in all of the required disclosures and observations that the Department of Labor, like other state agencies, have to include at the end of their proposed regulations, there is an analysis of needs and benefits related to the proposed rule, and it's broken down to an employer section and an employee section. The employer section, I think, is 3 sentences, and the employee section is something more like 7 or 8 paragraphs. The employer section begins, business and industry advocates agreed that many industries require flexibility and employers need a mechanism to adjust to unpredictable circumstances, like an employee calling out sick, a worker leaving unexpectedly, delays in the delivery of materials, or inclement weather conditions. The next 2 sentences then go on to explain why this rule is good for businesses. I think to the extent that businesses and industry advocates agreed what I just read, it was in the respect that this rule would only curtail that flexibility. And it's sort of backwards logic to argue that this rule provides that flexibility. The only way I can read it that way is if you start from the premise of, well, we really could have done something even more restrictive, but isn't it nice of us to have given you all this flexibility? Call me cynical if you like, but again, I represent businesses and I am an employer myself. The employee section, of course, extols the virtues of unpredictability, making it difficult for employees to schedule themselves and their personal needs and childcare and that type of thing, many of which are certainly valid concerns, but not necessarily enough to justify the extensive restrictions on employers throughout New York State that this regulation probably will enact. So I see there is a question coming in. As I mentioned, just make sure that we don't get anything too confidential here. There is my contact information on the screen if you want to follow up and ask something that way instead. The question we have maintenance staff that complete work orders as a major part of their job duties. This is for property management. Would the work order section apply to this position? I think that, first of all, as I kind of alluded to, this regulation wouldn't affect the business or the building services industry in the first place. So until that separate wage order somehow gets modified, the language here isn't relevant. If that language were added in there, or if we change the fact just a little bit, that seems like the type of thing that work orders could apply to, that work order carve out could apply to, but there's no further elaboration on that in the regulation itself. So I don't want to get into too much more detail in trying to articulate an argument for or against relying on that exclusion here. I'm going to go ahead and put up the link to the slides so you have those for future reference. Welcome any more questions still. As I said, I'll stay on to answer them. So you should be able to click and get the slides. If you're registered for this live webinar, then you will receive an email confirming your attendance and providing you a link to the slides as well that way. But again, I commend those of you who have joined for this webinar today and stuck through it. I think it is a very important topic. Admittedly, for a long time, I was trying to ignore it and hoping it would just go away. But having been reintroduced in December, I think there is a reasonable chance that we will see some form of these rules take effect, probably in the not too distant future. It's not obvious to me that the Department of Labor is just amusing itself by reintroducing virtually identical regulations, every year. They clearly mean business by them. They did receive a number of comments, undoubtedly, on the latest proposed rules. Maybe we will see some of those incorporated, and hopefully they will be helpful to employers. And then, of course, there is the other shoe that drops as to when and how similar or potentially different amendments come into play for the hospitality and other industries that are separately regulated. So I'm going to wait another minute for any last questions that come through. I will also mention that, of course, if there are new regulations implemented that are significantly different from what I've discussed today, I will likely have another webinar or other guidance information that I will make available. And if you're registered, you will get that information by email. Otherwise, I suppose we can all quietly sit back and hope that this won't become a hassle that employers in New York State have to deal with anytime soon. But I am just afraid that that might be wishful thinking. So with that, and not seeing any more questions, I will just thank you all again for your attendance and sign off at this point. It's been a pleasure, and we will see you next time.